Advocates of open government know that each session of the General Assembly gives birth to new attempts to stem the flow of information to the public. Under what circumstances would you attempt to combat these efforts and ensure that Kentucky's government remains open to the public?
In all instances, if there are individuals that are improperly attempting to stem the flow of information from the public, I, as Attorney General, will feel free to go before committees to advocate for the open government. I do not believe that the law should be restrictive. I think we should search for ways to make government more open and not less open. So I would work very hard to advocate for the public interest and see that the laws remain open for the public.
Mr. Conway.
Thank you very much. Before I get started, I do want to comment on Mr. Coleman's recent answer saying that I was trying to create a business unfriendly environment in the state. That's not what I'm saying. What I'm saying is there's one place in the open records law where there is a presumption against turning over information, and that deals with the Economic Development Cabinet. Kentucky is not a business unfriendly state in our contracting practices, yet bids, even failed bids, are open to inspection. We need to take a look at that one specific area, make certain we're not driving away businesses, but make certain that on the front end of that process, we have some agreement between our cabinets, the AG's offices, and businesses that may come to the state about what's proprietary information and what's not. I would, too, be an advocate for open government and freer access of information from government to the people or to the media. There are some legitimate exceptions, however. We have a new provision in the open records law dealing with emergency preparedness, vulnerability assessments. Those sorts of areas probably are legitimate exceptions to open records. Any type of investigations, any type of preliminary law enforcement, criminal investigations, those are acceptable exceptions. But again, I go back, let's construe those exceptions as narrowly as possible.
Mr. Kimball.
I drove through Tennessee once, and there were campaign signs up because it was October, and this one gentleman had these campaign signs with a smiling face on it. He's running for sheriff, and his slogan was something like fair-minded, fair, and reasonable. And I don't want you to think that we're just a bunch of inflexible individuals up here saying that this law means just exactly what it says, but that's the case. And typically, when you're a prosecutor, you have a lot of discretion as to what you do, but this isn't one of those areas because the law is so plain and so specific that it just tells you what to do. You have to enforce it like it's written. So I mean, the philosophy is right there in the law. You don't even have to have your own philosophy. It tells you what your philosophy should be. And if there's a bias, it should be toward more openness whenever possible. Thank you.
Mr. Larson.
I lost focus on the question. Would you repeat it for me, please?
Advocates of open government feel that at each session of the General Assembly, there are new attempts to stem the flow of information to the public. Under what circumstances would you attempt to combat those efforts and ensure that Kentucky's government remains open?
I guess the Attorney General is going to be asked about these things. Again, my opinion is that the prime job of the office is law enforcement. But at some point, an Attorney General has to be asked about something that's important to the people of the state as an elected official responsible to the people. And in that sense, when he's confronted with secret government, loss of business, just problems that need protection of the Attorney General, that's the ethical duty of a prosecutor in this state, to consider the interest of all sides.
Obviously, the opinion of most of us would be is that we would fight very hard. issue. I think we'd have to look at what is the purpose that is going by, or the purpose of this change. But there's a lot of things that I don't, that I see that I don't like with regard to the legislative process, that want to do the budget process behind closed doors, and those are kind of things that I find distasteful. But I think as the Attorney General, as Mr. Conway said earlier, can use it as a bully pulpit, and that's something that we haven't seen out of this Attorney General that we have now. We haven't seen it out of the Attorney General prior to this one. Now is we have an opportunity to get an Attorney General who will fight for open government, and that's what I'm going to do.
Mr. Larson, you'll have this next question first. This question was suggested by Shannon Mason, a journalism senior at UK, who is president of the campus chapter of the Society of Professional Journalists. This semester, the University Board of Trustees changed its practice and will not post its agenda until 4 hours before the board meeting, effectively limiting participation of those who might not be aware that a matter is to be discussed. While this appears to be within the provisions of the Open Meeting Act, SPJ wrote the board chairman suggesting it was not conducive to open government. If the board chairman called you for advice, what would you say?
I've been in this position as a student leader in the somewhat activist age of this early 70s. There was a discussion about what we couldn't do and what we shouldn't get into. Of course, now I'm a lawyer. You got to follow the law. I'd like more. And what's my opinion? I say open government because it'll make you seem like a better person, the officials of the administration.
Mr. Coleman.
Well, I think that it depends on how they call me. If they call me as Attorney General, I have to say I can't give you an opinion of that, because the Attorney General shouldn't give you an opinion. We're here to handle the appeal. But as they contacted me as an attorney, I would have